Welcome to the Michigan Supreme Court September public hearing on administrative matters. We have speakers on three different items. The first one is number 3 on our agenda, which is a proposed amendment to Michigan Court Rule 9.116 that would allow the Attorney Grievance Commission to initiate disciplinary proceedings against a former judge who departed from the bench but might have been removed or would have been removed otherwise. There are 3 speakers on this item. As is usual, we ask that you keep your remarks to 3 minutes. There's a handy little clock there to tell you how you're doing on that. But if there are questions from the justices, you could be on a little bit longer. The first speaker is Cynthia Bullington from the Attorney Grievance Commission. Good morning, Cynthia.
Good morning, Justice McCormick and other justices. I'm here on behalf of the Attorney Grievance Commission, and I appreciate the opportunity given to present to this court. The Attorney Grievance Commission supports the proposal of the Judicial Tenure Commission, and we also would request that the court consider a further amendment to the rule, which would give a reciprocal type of effect to the court's own opinion and order by putting that into the record of the disciplinary proceedings in order with a reciprocal effect. And essentially that rule language as proposed mirrors the language of Michigan Court Rule 9.120C, which concerns disciplines from that have been imposed against attorneys from other jurisdictions. And it's also to streamline proceedings, and it applies only to justices who have in fact been removed from the bench. The record would then essentially create a presumption that discipline will be imposed. The starting level for discipline would be that of a where disbarment would be considered a comparable discipline. Now, having said that, you take comparable discipline being disbarment, and somebody would be allowed to aggravate or mitigate from there. Comparable discipline is an important consideration when you examine issues of reciprocal disciplines coming in from other jurisdictions. That's why that language is in there. Judges and justices removed for misconduct from the bench have engaged in serious misconduct. And discipline in this regard is for the protection of the public, the courts, and the legal administration pursuant to Michigan Court Rule 9.105, so paragraph A. Unfortunately, we have had instances of serious misconduct by judges. For example, Judge Callanan, who was removed for bribery and other allegations. I want to thank this court for the opportunity to present.
Thank you very much. Any questions for Ms. Bullington? Thank you for your comments. We have one additional speaker on this item. It's Judge Lenice Bryant from the 36th District Court. Judge Bryant, good morning.
Good morning, and thank you, justices, and please excuse my slight tardiness. I was actually handling my docket and realized that it was 9:30. I do apologize. I am appearing on behalf of the Association of Black Judges of Michigan. We did submit a statement electronically, but what I want to piggyback on and actually state that we vehemently oppose the Attorney Grievance Commission's proposal. And one of the things that came to my mind was that there are lawyers who practice in the Michigan courts every day who may not be suitable for the bench. But those attorneys are not required to live by the judicial canons. When a judge is removed from the bench, it is because they have violated, in the Supreme Court's opinion, judicial canons. Those canons may make them unsuitable to be on the bench, but they do not automatically or necessarily make them unsuitable to practice law. In my courtroom in 36th District Court, one of the things we say is that we're here to not only cause you to have to pay the consequences for your crime, but we're here to change lives, change minds, and change attitudes. When a judge is removed from the bench, that is a severe penalty, whether they leave voluntarily in light of or instead of discipline, but that is a severe alteration to their life and their lifestyle. But also automatically giving them the consequence of not being able to practice law, feed their families, support themselves, that should not be automatic. In our response, we indicated that there are a little bit more steps that you have to go through at the Attorney Grievance Commission in order to remove a lawyer versus removing a judge. A judge should not be not afforded that opportunity just because, or a lawyer who is a judge should not be taken, those opportunities shouldn't be taken away just because they were once a judge. And that is stated in our response. People make mistakes and people make bad decisions, but they should still be afforded every due process if you're talking about taking away their ability to provide for themselves and for their families. So we vehemently oppose those recommendations as it relates to the reciprocal discipline or anything like that. We stand by our statement, and if there are any questions, I would love to answer those questions. Again, thank you for the opportunity to speak on behalf of the association.
Your Honor, if I may, I'd like to ask a question. Can you give like a real life example of where you feel this would be of concern?
A real life example. Well, there are some judges who may have, for example, left the bench in light of some things that were that was brought to their attention that they may have felt they would be removed from. So a judge can be removed for things that are less than criminal. So the example that was given by the Attorney Grievance Commission was a criminal act, but judges can actually be removed from the bench for actions that are less than criminal. And if I am removed from the bench for something that is not criminal, and then the Attorney Grievance Commission can automatically also take away my license to practice law. There are judges who may have, some type of mental defect or be going through some stress or going through some situations, for example, I don't know, drug addiction maybe, or some type of addictions that may cause them to have to be removed from the bench based upon the Supreme Court's determination. But if I go into treatment or if I do something to get myself back together, that shouldn't also mean that I have lost my ability to practice law and to provide for my family.
Thank you.
Bryant,
Thank you, Your Honor.
Judge Bryant, could I ask you a question just to make sure that I understand your position? And I think I do, is that the association's objection would be to the notion that the AGC automatically can discipline a judge who has been removed from the bench, as opposed to, but I don't read the rule or the proposed rule necessarily as saying that they automatically are subject to discipline by the AGC, but that it allows the AGC to conduct an investigation. And in a situation like you're suggesting, that perhaps the conduct warranted removal from the bench under the Code of Judicial Canons, but it may not necessarily be an actionable, case under the AGC's, the rules of professional conduct. As long as the rule doesn't say that you automatically get disciplined by the AGC, it just allows them the authority to actually conduct an investigation and make that inquiry that you're suggesting needs to be made.
Yes, I believe you're stating it correctly. What we're vehemently opposed to is the AGC's suggestion of the change that will give them that reciprocal jurisdiction. What we're not opposed to, and I believe it was stated in our response, is we're not opposed even to the JTC making a referral to the Attorney Grievance Commission and saying, this is what we've done and this may be actionable. In our opinion, that would be no different than me making a recommendation to the Attorney Grievance Commission based upon a lawyer's conduct in my courtroom. So we're not opposed to that. Because we do believe that there are some things that a judge can do on the bench that may also mean that they should not practice law, but definitely not an automatic removal based upon what the Attorney Grievance Commission was requesting of this court.
Okay, understood. Thank you.
You're welcome.
Thank you, Judge Bryant. Any other questions for Judge Bryant? Thank you so much for taking time out of your docket to be here this morning, Judge.
Thank you so much. And am I free to return to my docket?
You are free to return to your docket.
Okay, thank you so much. Thank you for your time.
Absolutely, thank you. The next item that we have speakers endorsed for is number 5, which is a proposed amendment to Michigan Court Rule 7.305, which would clarify that the 28-day timeframe for filing an application for leave to appeal applies to cases where the respondent's parental rights have been terminated. We have 3 speakers endorsed on this item. The first is Attorney Scott Bassett. Good morning, Scott.
Good morning, Chief Justice McCormick. I'm here representing the Michigan Coalition of Family Law Appellate Attorneys. And we understand the purpose behind the proposal, but we actually think that there's a better and more logical way to clarify what appellate rights are and the appellate timeframe. We think that this is actually the worst type of situation to shorten the appeal period to the Supreme Court from 42 days, which applies in all other civil cases, to 28 days only in cases where parental rights have been terminated. These are fundamental rights, among the most fundamental rights protected by our Constitution. And the parents whose rights are terminated are also in some of the least advantageous positions to retain appellate counsel. Many of them have court-appointed counsel from the trial court to the Court of Appeals, but their court-appointed counsel only applies to the appeal to the Court of Appeals. And if they receive an unfavorable decision from the Court of Appeals, they then have to go back to the trial court and request authorization to have their court-appointed attorney allowed to represent them in the Supreme Court. The time it takes to do that will often exceed the 28 days that they are allowed under this proposal. And they could be denied that opportunity by the trial court, in which case they then have to seek either retained counsel, which is difficult given their financial means, or pro bono counsel. And I've been in that position, as have the other speakers who are going to address this issue. And we're coming into the case cold, trying to get up to speed and facing a 28-day appeal period. So we have proposed an alternative, and that's simply to have a straight 42-day appeal period for all civil appeals. One of the additional problems of having a separate appeal period for cases where parental rights have been terminated is that we have a situation where the appeal period is determined by who prevailed in the Court of Appeals. That's a somewhat, I guess, disturbing situation where, it doesn't happen often, but if we had a termination of parental rights issue involving both parents, and for whatever reason, the Court of Appeals may have affirmed termination for one parent and reversed for the other, we could conceivably have the state being able to appeal, taking advantage of a full 42-day appeal period, and the parent appealing the same decision being left with a 28-day appeal period. I think that should offend perhaps our sense of justice. So we propose that we have a straight 42-day appeal period for all civil appeals, including appeals from termination of parental rights orders.
Thank you, Mr. Bassett. Are there questions for Mr. Bassett? Okay, thank you so much for your input. The next speaker is Joshua Peace from the State Bar Children's Law Section. Good morning.
Good morning. Thank you, Your Honor. I don't think that I can state our position any better than Mr. Bassett did. We are joining with the Michigan Coalition of Family Law Appellate Attorneys in requesting a straight 42-day period for application for leave to the Supreme Court in all civil cases. The one thing I will add is I did speak with some experienced and well-respected practitioners in this area who have indicated that they have turned away what they felt were meritorious cases and cases that deserved consideration by the Supreme Court because they were not able to adequately gather the materials they needed and review the record and prepare an appropriate application for leave given the short period of time. And as Mr. Bassett stated, for the most part, these are working with litigants who are limited in their financial resources and often have to scramble to try to put resources together to obtain counsel. So, and as Mr. Bassett also noted, these cases involve the permanent and final severance of what is recognized as one of the most fundamental constitutional rights. And it's the position of the Children's Law section that these should be afforded the same amount of time for an application for leave as in any other civil case. So we would ask that the court, rather than have different time periods depending on the type of case, set a straight 42-day period for application for leave in all civil cases. Thank you.
Thank you. Any questions for Mr. Peace? Thank you so much for being here. The final speaker on this item is Lisa Speaker, representing the Family Law section of the State Bar. Good morning, Lisa.
Good morning, Chief Justice and your honors. The Family Law section also agrees with a letter submitted by the Michigan Coalition of Family Law Appellate Attorneys. I just wanted to add a little bit of personal perspective, having represented both prospective adoptive parents in adoption cases and also parents whose rights have been terminated in the child welfare context. And the 28 days that are given to terminated parents is frankly just not enough to mount, even to evaluate whether it's appropriate to go to the Supreme Court. The only instance in which that's even possible is when, for example, when I, as an attorney in the Court of Appeals, have already worked on the case, but so many times these cases do not come to our attention until there's a decision by the Court of Appeals. And sometimes those are published decisions that are binding on everybody. And yet there's, even to get a group of pro bono attorneys together and try to get everything figured out and review the record and articulate the issues and why this court should look at it, if it should at all, it's just not feasible to do so in 28 days. And I do echo the comments you previously heard that we have turned away cases that we might have even been willing to do on a pro bono basis because it just wasn't sufficient time. So I think it evens the playing field. That it's really kind of confusing. I mean, I like the rule proposed because it was confusing before. And I always filed adoption appeals where termination was denied within 42 days, and this court has agreed with that. But it takes away the uncertainty of that issue. But I think the rule can be improved even more by just making it 42 days across the board, regardless of whether it's a prosecutor appealing, an LJAL. You know, everybody should have the same appeal period in these types of cases. And really, if the case is important enough, we need that time. And the other thing I want to add is that adding 14 days to that time period for the terminated parents is just a drop in the bucket. I mean, the Court of Appeals often takes 8 to 10 months, sometimes longer, to reach a decision on a termination of parental rights case. So adding a little bit of time to even so that attorneys can even evaluate whether it's appropriate to pursue a case is really not adding that much more to the whole process. And we ask that the court modify the rule as proposed by MICFLA.
Thank you, Ms. Speaker. Any questions for Ms. Speaker?
Speaker, I just wonder if you could speak to having, as you said, like your work also representing families in adoption proceedings. If the shorter time period, you know, is if there's a benefit to, you know, speeding time to permanency, right, in the adoption context. I mean, yes, it's a difference of 14 days, but does that, in your work in handling adoption cases, is there a benefit to having a shorter time period in those cases?
Well, like I said, I think that the 14-day difference is really a drop in the bucket, considering how long it takes the case to go through the Court of Appeals. And although the cases are expedited and we appreciate that, it still takes a significant amount of time to get through the Court of Appeals. So I just think it overall makes it easier to understand that everybody has the same amount of time. we can easily count to 42 days. When the 42 days pass, then the adoption can be finalized in the case where a parent's rights have been terminated. And I hope you weren't asking about making it the same time period for the prospective adoptive parents when termination is denied, because 28 days, frankly, is just not enough. The problem with these cases is that if the attorneys who end up working on the Supreme Court case were not involved at the lower levels, 21 days to file a motion for reconsideration is really not practical either. And so the only fail-safe measure is to have a 42-day window for the Supreme Court, because we don't have time to get a motion for reconsideration in within 21 days. And adding another 7 days, like if you can't get a motion for recon in within 21 days, you're not going to be able to get a Supreme Court application in 7 days later. So when I represent a party, we can figure out a way to get the motion filed within 21 days. But a lot of times these cases are the people that are really interested in following the law and improving the law aren't the ones that necessarily were working on it below and in the Court of Appeals. And so because there's a lot of attorneys in the state who are very interested in making better laws for the state and better interpretation of the laws, that those people aren't aware of these cases until the decision comes out from the Court of Appeals.
Okay, thank you.
Thank you.
It's been a long time since I practiced law, but my memory is you get done what needs to be done by the time frame that's allotted. But that being said, is there a middle ground here? Is 35 days perhaps the right number? Obviously, what we're trying to do is expedite these things, make them different. They're, as you point out, they're expedited in the Court of Appeals. Maybe we need to work on getting the Court of Appeals to act even sooner.
So I appreciate your comments, Your Honor. And if this court were to adopt 35 days, then I still think it should be the same for all the players in the case, so that you don't have a different time period depending on who you represent. So, I think 35 days is obviously better than 28 days. The comment about you're going to get done what you need to get done in the time that's given to you. The problem is when you're brand new to the case, and I've had this multiple times where I don't come onto a case until after the Court of Appeals decision, because I find out about the case or somebody finds me after they've lost. And that happens in both adoption cases and termination of parental rights cases. Sometimes even just getting the record from the attorneys and getting the things we need to review is not as you think it would be easy, because we have e-filing and whatnot, but sometimes things are not as fast as we would like, and it's still a struggle even at that stage of the proceeding when a Court of Appeals has issued a decision. And it's really hard you can't just write an application to the Supreme Court based on a Court of Appeals opinion. You really need to know what happened below and not just the briefs. You need to kind of figure out, if you think the Court of Appeals is wrong, where did it go wrong? And maybe it's because briefing wasn't good enough and you really want to see what actually happened. And we've done that. We've ordered records from the Court of Appeals on cases just because we're interested in them, not that we were planning on pursuing it on behalf of anybody. But needs to be time budgeted into that process. So I personally, I think I could live with a 35-day window, but I just still think it should be the same for everybody.
Thank you.
Thank you very much. Any other questions for Ms. Speaker? Okay, thank you all for your comments this morning. Very helpful. The final item that we have speakers endorsed for is number 8, a proposed amendment to Michigan Court Rule 3.613 that would clarify the process courts must use after receiving a request not to publish notice of a name change proceeding and to make the record confidential. We have a number of speakers endorsed on this one. The first one is Joshua Peace from the State Bar of Michigan Children's Law Section.
Thank you again, Your Honor. So I will note that we do support the proposed ADM file. However, we believe that there are a few amendments which would improve it as well. Our concern is that the potential risks to petitioners go beyond physical safety. And we believe that it would be appropriate to include as good cause for making the record confidential, risk of domestic violence, harassment, emotional or psychological abuse, or other maltreatment. Where our concern is that folks seeking name changes are at a risk of things beyond their physical safety, and including that expanded list of potential risks will provide safety to a greater percentage of people who are seeking name changes. So we would ask that the court amend subsections C and C1 to include risk of domestic violence, harassment, emotional or psychological abuse, or other maltreatment as good cause for trial court to order that the proceeding be confidential. Our other concern that we are requesting some amendments before this is adopted regards publication, specifically when talking about providing notice to non-custodial parents. Our concern is that a notice which is published one time in a newspaper and contains neither the current nor the proposed name of the child is insufficient to notify a legal parent about a matter which implicates their rights as a parent. Specifically in the new subsection E2, we believe that it would be appropriate to give the trial court discretion to determine what methods of alternative service would be appropriate for proper notice of the proceedings. Service through email, social media, or other electronic means may be appropriate. We don't believe that trial courts should be limited to newspaper publication when other options are available. So we would urge the court to consider amending subsection E2 to allow a court to provide to order notice by alternative service rather than mandating publication only. And the last place where we would urge the court to make an amendment is subsection 3C or C3C, which states that the court could not publish the current or proposed name of the minor. We believe that if we're talking about notice to a non-custodial parent, it would be appropriate to allow the court to order publication of the current name of the minor, although we do support not including publication of the proposed name. So we would ask that in C3C, the words current or be struck from the proposal prior to adoption. Thank you.
Thank you very much. Any questions for Mr. Pease? All right, next speaker is Kim Kramer from Michigan Legal Help. Good morning, Kim.
Good morning, justices. Thank you so much for the opportunity to comment on this rule. My name is Kim Kramer. I'm a lawyer at the Michigan Legal Help Program. We provide a website with self-help resources to help the many Michigan residents who need to face a legal problem without a lawyer. I'm appearing today to support the amendment of Michigan Court Rule 3.613 and also to support the comments of the coalition presented by DICOMA and from the Access to Justice Policy Committee of the State Bar. These comments suggest a rule that would include a presumption of good cause to waive the publication requirement for gender affirming name changes. Name change is a popular topic on Michigan Legal Help. In 2021, our do-it-yourself name change tool was accessed 10,563 times. We also get questions on our live chat service and in our email about how to waive the publication requirement. Since this waiver process is not standardized across courts and there's no court form for it, it's hard for us as a statewide organization to give visitors information about how to do it. So far, we've given a blank notice of hearing in motion form with some basic instructions. And while we hope that visitors are successful, we know that navigating a complicated legal process with a blank form is not always a ticket to the relief requested. We recently drafted an update to our name change tool that will help people with a motion to waive the publication requirement. So far, this is still in development, but I'd like to share some of the difficulty we faced creating a broadly applicable tool for our statewide audience that also includes protections for trans and non-binary people. The evidence that a trans or non-binary person might use to show fear of physical violence could be very different than the evidence a judge might expect to see. There might not be a history of physical violence or threats to the petitioner. The petitioner might not be out to some people in their lives or communities and could fear violence based on anti-trans views that those people express generally. This fear is real, legitimate, and a uniquely horrific experience for some trans people. Human Rights Campaign data shows that 2021 was the deadliest year on record for trans and non-binary people. And for someone who lives with this fear each day, saying an emotion that they fear violence because they're a trans person may be the clearest way they can imagine to explain their fear of violence. Some judges, however, might not see the connection. And while we try to guide viewers with examples of presumption would make this process clearer, fairer, and less traumatic for people who are requesting a gender affirming name change. Difficulty explaining a need to waive the publication requirement also means that someone seeking a gender affirming name change will need to pay the $100 publication fee. Many people come to our website seeking a fee waiver, but this publication fee is not waivable under the court rules. Thank you again for the opportunity to comment, and I can take any questions you may have.
Thank you. Any questions for Ms. Kramer? All right, thank you for your comments. The next speaker is Julissa Abad from Fair Michigan.
Hi, everyone. Again, thank you for allowing me to give comments. So good morning. My name is Julissa Abad. I am the Director of Outreach and Advocacy for the Fair Michigan Justice Project. Fair Michigan originally started in Wayne County. We prosecute crimes against the LGBT community. We've done over 30 with a 100% conviction rate. We've partnered with Oakland County, Washtenaw, and Ingham. I do a support group for trans women of color. I also have an expungement program through the University of Michigan for low-level offenses. And I've partnered with Dykema Ford and GM, where I've helped over 149 trans individuals here in Michigan change their name. I'm also a member of the transgender community, and I provide a voice for many members of my community who do not have a voice. I think it's important that the Michigan Supreme Court hear from a member of the trans community why obtaining a legal name change is so important and why current publication requirement puts our safety and our lives at risk. Having a legal name change that represents our gender identity and our gender presentation is an affirmation of who we are, how we live, and how we can be our authentic self. The current legal name change process provided by the Michigan court is both a complicated and expensive one that intimidates, excludes, and marginalizes members of the community. The publication requirement involves publishing one's dead name, the name assigned to a trans individual at birth, which is often at odds with their gender identity, along with the legal name that they hope to attain. This required information outs a trans person and makes them fair game for not only discrimination in employment, housing, and public accommodations. As we know, Michigan was an at-will state. Trans people out of the LGBT umbrella, particularly trans women of color, experience the most marginalization and violence. A trans woman of color's life expectancy is 35 years old. Hate crimes, including murders against transgender people, particularly trans women of color, have been on the rise in this country, and Detroit is no exception. In the past 2 months, we have seen the murders of 2 trans women of color, Dee Dee Davis and Hayden Davis. Cases are not related from 2 different defendants of just the danger that trans people experience. As members of the Michigan's highest court, it is my hope that you consider a court rule involving a legal name change, that you consider the perspective of the trans community participating in a legal process in order to live our true authentic lives. Ironically puts our lives at risk. Violence against transgender people is a real and everyday thing, and our ability to have access to the courts means we need to make sure that we are safe in doing so. Providing a way to waive the publication requirement for a name change is an important first step. So thank you.
Thank you very much. Any questions for Ms. Abad? Thank you for your comments. Next is Jay Kaplan from the ACLU of Michigan.
Good morning, Chief Justice and your honors. I'm the staff attorney for the ACLU of Michigan's LGBTQ project. Our legal program advocates on behalf of the rights of transgender people, and majority of the requests that we receive for assistance are from the trans community. We also participate in a legal name change clinic, which provides assistance to indigent members of the trans community for obtaining legal name changes. A court rule which provides for a presumption of good cause to waive publication for petitioners who are transgender, survivors of domestic violence, or trafficking victims is a much needed component to the legal name change process. Again, it's important to note, as Julissa said, that the published notice of hearing identifies both the birth name of a petitioner as well as the legal name they have requested, in essence, outing a transgender petitioner to the public and subjecting them to discrimination and threats of violence. Currently, many Michigan courts in their instructions to petitioners make no mention about the ability to file a motion of waiver of publication. Last year, we heard from a transgender woman that in Kent County, they automatically send out a notice of publication to the local legal news, and then they bill the petitioner. When this woman asked about a waiver of publication from the court, she was informed by the Kent County clerk that she could not obtain a legal name change without publication. Both Oakland and Macomb County courts, in addition to not letting a petitioner know about the option of requesting a publication waiver, automatically publish a notice of the hearing and include that in the cost of obtaining a legal name change. And where transgender petitioners have filed motions for waiver of publication, such as in Wayne County, judges have been inconsistent in deciding whether threats to a transgender person's physical safety constitutes good cause for a waiver. We believe that all of this reflects a lack of understanding and cultural competency regarding transgender petitioners and the importance that obtaining a legal name change means to their lives. Transgender people report being misgendered, disrespected, and their safety concerns disregarded by Michigan judges and court employees. It should come as no surprise that a recent study by Lambda shows that only 28% of transgender people trust the courts to treat them fairly, a figure that's even lower than trust in the police, which has a long history of mistreatment and harassment of this community. The proposed court rule amendment and Board of Commissioner recommendations regarding a presumption of good cause would provide much needed structure and guidance to Michigan judges and would provide a uniform and humane, safe process for transgender petitioners seeking a legal name change. Thank you.
Thank you, Mr. Kaplan. Any questions for Mr. Kaplan?
I do. Mr. Kaplan, do you believe that the presumption is something that, or changing that, or is something that the court can do, or is that legislative?
No, we believe that it is something that the court could do. There have been instances where, for instance, with regarding the PPO process, where the rules itself are more expansive than the statute. So we believe that it is within the authority and the parameter of the court to be able to do something like this.
Okay, thank you.
Any other questions for Mr. Kaplan? Thank you. Next is Heidi Nasco from the Dykema Law Firm.
Thank you. And thank you for allowing me to comment today. I am Heidi Nasco. I am pro bono counsel at Dykema for the past 16 years. And together with community, Dykema has created 2 legal clinics for low-income trans people seeking name changes as part of their gender confirmation process. I've supervised or directly handled close to 150 pro bono legal name changes since 2015 from Washtenaw, Wayne, Oakland, and Macomb counties. In April 2021, I was part of a coalition of lawyers and community members who suggest changes to the court rules because of voluntary tyranny experiences issued with publication. This proposed revision was proposed instead. The research about trans people in America demonstrate that they experience violence, harassment, and discrimination at much higher rates than those who are not. In 2016, the transgender survey conducted by the National Center for Trans Equality found that the discrimination against trans people is pervasive in employment, housing, education, and public accommodation, including access to healthcare. The report shows that 63% of survey participants have experienced, quote, a serious act of discrimination, one that would have a major impact on one's quality of life and ability to sustain themselves financially or emotionally, end quote. The most recent FBI hate crimes report shows that hate crimes against trans people, particularly women of color, have increased over the past 2 years. The U.S. Transgender Survey also found that 35% of those surveyed had not obtained a legal name change due to the costs associated with the court procedure. Given the pervasive discrimination experienced by the trans community, having identity documents that do not match your gender identity can be a grave concern for that person because it outs someone as being trans. Publication of a legal name change related to gender identity outs that individual as being trans and can and does attract harassment, discrimination, and physical harm. The research does bear that out. I support the revised rule, but also urge the adoption of the Board of Commissioners suggested revision, which provides, once an applicant files a request for publication waiver, that the court rule should afford a presumption of good cause shown if the name change is sought because they are transgender, a victim of domestic violence, or trafficking. This presumption would be consistent with the research and our volunteer attorneys' experiences that our clients experience discrimination, harassment, and regularly, and publication of a name change increases the risk of more violence happening to our clients. I also urge the court to rethink the proposed section C8, which would, as written, allow the court to adjourn or dismiss the entire petition if the applicant failed to appear at a hearing following a denial on an ex parte motion or to deny the publication waiver. Instead, I propose that the court only allow the petitioner to dismiss the petition or publish notice despite the denial of the ex parte motion. Thank you.
Thank you, Ms. Nasco. Any questions for Ms. Nasco? Thank you for being here. Next, we have Lori Kitchen-Bushel, the Executive Director of First Step.
Thank you. Since 2018, I've served as the Executive Director for First Step, the Domestic Violence and Sexual Assault Comprehensive Agency of Wayne County. We were founded in 1978. We provide emergency shelter, counseling, advocacy, the county's 24-hour crisis line, assault response, and community response with deep partnerships in several police departments and court dockets across Wayne County, all free of charge. First Step has interacted with and supported over 45,000 survivors of domestic and sexual violence of all identities and backgrounds. First Step has also served survivors of sex trafficking. When domestic violence survivors leave their assailant, they often need to interface with multiple aspects of the justice system, both civil and criminal proceedings, while also navigating an exhaustive list of barriers to their safety and self-sufficiency. Evidence is also clear that when a survivor is fleeing, the violence asserted by the assailant increases and intensifies. When part of the separation process necessitates a legal name change, survivors need a clear and obvious path to do so. So often the court system is completely unnavigatable without an attorney, creating additional barriers to safety on an already exhaustive list. We support the proposed revised rule and the Board of Commissioners' suggested presumption of good cause shown when the applicant identifies domestic violence, trafficking, or gender identity as the reason justifying the name change. Not only will the presumption expedite the legal process, but a presumption will also more consistently grant a waiver of publication and thereby reduce costs and additional barriers people seeking a name change to increase their chances of remaining hidden from assailants. Thank you.
Thank you very much. Any questions? Okay, next is Professor Elizabeth Campbell from the University of Michigan. Good morning.
Good morning. Thank you, Justices, for listening to my commentary. I am commenting in support of the Board of Commissioners' recommendation to make good cause required under subsection C presumptive for persons whose name change is sought due to being a victim of human trafficking. I'm an assistant clinical professor of law in the Human Trafficking Clinic and the co-director. I have been with the clinic for 11 years and have represented hundreds of trafficking survivors, both labor and sex. My office frequently represents survivors seeking to have their names changed. I want to share a bit about why trafficking survivors seek name changes and why the current publication rule is such a significant burden when they seek to do so. There are two primary reasons a trafficking survivor seeks a name change. The first and likely most obvious is that the trafficking survivor faces a real sort of risk or danger as a result of their victimization, either from the perpetrator or from the perpetrator's network. The rate of prosecution for trafficking is abysmal, and so it is very rare that a survivor can feel comforted that their perpetrator is incarcerated and that they are in fact safe. And even in the rare occasion where there does happen to be a successful prosecution, often there are other involved parties who still pose a risk to survivors, even if one of the traffickers has been incarcerated. The second and likely less known reason that a trafficking survivor might seek to have a legal name change is that they come to this country under an identity that has been created by their trafficker, meaning their original birth identity has been changed for the purposes usually of immigration fraud, and they come to this country with a whole new identity. Upon escape, they wish to return to their birth identity, but they're unable to get the necessary proofs from their home country to satisfy our immigration system. There are really sort of strict requirements to change a person's name in our federal immigration system. And often these survivors come from countries that simply don't have the necessary record keeping to satisfy the immigration system. So that's the other reason that they often seek to change their name. The most profound reason that the publication rule is burdensome to trafficking survivors is safety. The whole purpose of the name change is to conceal their identity from their perpetrator. This is true for both labor and sex trafficking survivors. Further, the fear of being outed as a survivor of sex trafficking is quite real. There remains significant stigma for those engaged in commercial sex work. I can't tell you the many times that I've advised a survivor of the publication rule and they just simply say, I'm not moving forward. I advise them of the possibility of the waiver, but without a strong assurance it will be granted, which I cannot provide. They simply don't move forward. For all of my clients, the monetary and administrative costs are overwhelming. The publication fee averages about $100 and is not waivable. If I'm representing them, I have donors to cover those costs, but most people are pro se and don't have those funds. Further, most pro se clients can't navigate the waiver requirements, what it would mean to write a waiver requesting that the publication not be required. For these reasons, I'm strongly in support of the Board of Commissioners' guidance to make it presumptive that good cause is shown if you are a victim of human trafficking. Thank you.
Thank you very much. Any questions for Professor Campbell? All right, our final speaker on this item is Heath Lowry from the Michigan Coalition to End Domestic and Sexual Violence.
Thank you, Honorable Justices. As stated, I'm a staff attorney from the Michigan Coalition to End Domestic and Sexual Violence. We're a statewide coalition that represents 73 local domestic and sexual violence service providing agencies across the state. Our members lead prevention efforts in their communities. They provide shelter, therapeutic resources, and legal advocacy as survivors navigate the legal system. I appear here today to support the rule change, but with the proposed changes by the Board of Commissioners of the State Bar of Michigan. The amendments with these changes would protect survivors from further threats of violence that could be induced by name change proceedings. Perpetrators are most dangerous when a survivor takes a step to leave that perpetrator's control, and these name changes are considered one of those steps. And as a result, confidentiality is an essential element for safe participation of survivors of domestic violence. And this presumption would be a safeguard for survivors' health by facilitating the evasion of these perpetrators. And additionally, this presumption would be especially impactful for survivors also seeking to affirm their gender identity. When compared to cisgender individuals, transgender individuals are the target of intimate partner violence at a dramatically higher rate. And seeking gender affirming, identity affirming services elevates the danger for the survivor even more. And due to the inherent safety concerns facing survivors, a requirement that an individual publishes notices of intent to change one's name puts that individual at a risk that far outweighs the benefit gained from publication. A legal name change would be integral to a process for survivors to escape and heal from intimate partner violence. So we support the rule change with the comment provided by the Board of Commissioners, and I'd be happy to answer any questions.
Thank you. Any questions for Mr. Lowry? Okay, well, thanks to everyone for your comments this morning. That concludes today's administrative hearing. Have a nice day.